there's an even more complicating factor, because in Michigan, we have a special deferment program called 769-4A, and that's just the statute that authorizes this. In domestic violence cases, a first-time offender can be given this special form of probation. And this probation says if the person satisfies all their terms and conditions, and that frequently will be things like, you got to go to batters counseling, you have to maybe do some community service, pay a fine, probably go to something that's called a victims impact panel, where you have to hear about the sort of awful effects that long-term abuse can have. And frequently you'll be looking at a situation where you'll have to get a domestic violence or batterer's evaluation, typically by a forensic psychologist that is chosen and hired by the court to tell the court whether you're a person who has a problem and is likely to reoffend down the road. All of those things, but if you do them all, and you complete them successfully, and you'll be on probation for 9, 12, maybe 18 months, and you get all those things done properly, the case against you is dismissed. You don't have a record at all. And people hear that, and it's really tempting. Like, well, sure, I could go and spend a lot of money on a lawyer, and I can fight this, but I have all these things stacked against me. They're going to go after me even if my wife doesn't want them to. And here I have this opportunity to plead guilty under this deferred sentencing program that allows me to just wash my hands of this and be done. I don't even have a criminal record. Why wouldn't I do that? Well, there's some really, really important reasons why. And it starts with this. Once you go down the road of domestic violence convictions, far too often, that first conviction, sure, it sounds like an easy deal. It sounds like a great deal. You walk away from it with no record, but it's there. It's not completely gone. The police know about it. The prosecution knows about it. The next time you're arrested, you're looking at a second offense. The next time after that you're arrested, you're looking at a felony. So not only does your spouse, the complaining witness, have a lot of control over, look, you better, if you don't let me have the kids this weekend, if we're in a custody battle, I'm calling the police and saying that you assaulted me. So that you cede a ton of control to the alleged victim of that domestic violence. But the court and the prosecution, they take an incredible amount of control over your life. The next time you're charged, you don't have that that protection of 769-4A. So frequently, the first charge is a weak case, and that's why the prosecution signs off on 769-4A, and the court grants it to begin with. There's not any visible injuries. They don't have an excited utterance. There is no 911 call. So they're like, look, we'll give them the special probation, and nice and easy, everyone's happy. And then the next time you could have fought that case, you could have won that case. The next time you're arrested, it's a really difficult case to defend. There is a 911 call. There are independent witnesses. There are physical injuries, and you come to a lawyer, and I can't tell you how many times I have people come to my office and say, what really stinks is that first charge was really weak. It was bogus. I just pled guilty because my public defender told me to do it, or I didn't want to hire a lawyer, or I hired a lawyer but didn't want to spend a lot of money, and they told me that this special probation would mean I didn't have a record. It's so common, and my answer to them is going to be, I can't change the past. I can only change the future. You want to fight this case? We're going to fight this case, but this case is a difficult case to defend. This case is a strong case against you. The case you should have defended was the first one. Acquittals, not guilty. Dismissals, case dismissed, are always better than 769-4A under any circumstances. That doesn't mean the first time someone gets arrested for domestic violence, every case should be fought. Some are appropriately resolved and adjudicated under 769-4A because that's the way they should be handled. But not every case should be handled that way. Many of them should be fought. And the only way to know which camp or side your case is on is to consult with an attorney.